Hello, everyone, and welcome to another episode of the TCLF One-on-One Series. Through the One-on-One Series, we aim to interact with the best legal professionals from India and around the world. Today, we'll be talking to one of the most distinguished competition law practitioners in the industry, Dr. Vijay Kumar Aggarwal, about his journey in the field of competition law, his experiences, some of his upcoming work. Sir has a monumental experience in the field of competition law. He has practiced before the erstwhile MRTP Commission as well as the present day regulator, that is the Competition Commission of India. He has written multiple articles and commentaries on the field of competition law, as well as he has been invited by various law schools around the country to deliver lectures in the field of competition law. Sir, it is an honor to have you with us today.
Thank you. Thank you, Shashwat.
Sir, I would just like to start by talking about your journey as a lawyer. So, what inspired you to become a lawyer, and what has the journey been like till now?
Okay. At the outset, I must congratulate the team of Contemporary Law Forum for organizing the talk on the competition law in India. I'm quite hopeful that this talk will not only benefit to the law students, but also to the competition law practitioner across the country. Now I come to your question. I will tell you that I am a first generation lawyer. In fact, I declare because of my circumstances. Just after passing my higher secondary in 1969, at that time 10 plus 2 system was not in vogue. I had to join a private firm and continue my graduation through correspondences. Thereafter, in 1972, I got government clerical job, and it was in subordinate courts in Delhi. I continued for higher aspiration for I appeared in many competitive exams, but of no avail. In the process, about 4 have passed. I have no option, but I have gained the experience of court. I thought that I must do my LLB now. So I started LLP. In graduation, I didn't have much percentage. Therefore, I forced do the MCOM, and after getting the score, I did my LLB and also diploma in labor law, all through evening courses.
Right.
So after passing my exam, I clear in a judicial exam in 1984, but I could not succeed. However, in 1986, I passed the UPSC and appointed in gazetted post in MRTP in 1986. And till 1990, I was there, and therefore, at the age of 40, I quit the government job and started my own practice.
Right.
So it was the circumstances that I become a lawyer. I completed all my education in through correspondences or evening courses while
Right.
working. So that is how I become a lawyer. So since 1993, I am doing my practice.
That's a very inspiring story, sir, and that's a story of fighting your challenges and just keeping moving on. And you have
Correct.
what you have achieved as a first generation lawyer. I'm sure it will be inspirational to all of us, who are also going into the practice of law with this fear of having come to a very new place with no sort of family backgrounds and all. So that's a very inspiring story, sir. But sir, the next step in your career, you were of course placed with the MRTP Commission, wherein you got your, I think, first exposure with competition law. Now, competition law, sir, is a very dynamic field. Anything that happens in this field, whether it is by the entities themselves or the decisions that come through the regulator, everything has a real-time implication on the market conditions or on the particular market. So, sir, what was it about the field, competition law, that attracted you the most, and you decided, that I have to specialize in this field of law?
It's very interesting question, Shishwat, which you have asked from me. I will tell you about this subject also. You see that my stay with the MRTP Commission was about more than 7 years. During that period, I had first-hand experience of the working of nitty-gritty of the MRTP Act. So
Right.
that created some kind of a passion in me, and
Right.
I started reading it more passionately. After seeing my interest, the MRTP Commission mandate me study leave to a PhD, and government has granted me study leave for this purpose. The
Right, sir.
topic of my research was a study of unfair trade practices in India under the MRTP.
Right,
So
sir.
probably this was the first research study on this subject in India. I am talking of 1990.
Right,
I
sir.
got registered in somewhere in 1988 and completed my PhD in 1991. So probably
Right, sir.
construction was also vogue in 1986. So it was a complete new branch. I
Right, sir.
had a first-hand knowledge of subject. Therefore, I was able to complete my PhD, which I again said it was probably the first of its kind in the country.
Right, right, sir.
So
So,
it was my passion which has created interest, and I at this later age, because I started the practice at the age of 40, so it was not properly here and there. So I concentrated only on the subject MRT,
right,
which
sir.
is, you have said rightly, it is a dynamic law.
Right,
It deals with the economics.
right,
So I liked it because economics was also my one of the subject in MCOM. So
right,
this was the reason that I started practice wholly in competition law.
right, sir. And sir, that's very fascinating to hear because students like me and even my fellow colleagues and batchmates, we have been mainly exposed to the Competition Act of 2002, and the field has evolved so much in India itself that every day there is some kind of a new path-breaking decision, whether it's on cartels or whether it is on dominance cases. And to hear someone who has followed this journey right from the day it started in India, the MRTP Act, its practice, its first decisions and all, it's so fascinating to hear that you have been a witness to all these changes. And sir, with that, you have had the experience of dealing with the present day regime as well. You have been seeing the changes as well as your practice and exposure to the erstwhile regime. So sir, in your experience, uh, what are some of the essential skills? For example, I want to be someone who specializes in the field of competition law. So, what are the skills that you think are very essential for a lawyer to specialize in the field of competition law?
Really, this question is very, very important for the practitioner who want to join as a career in the field of competition law. From my experience, I will tell you 4 points which, according to me and my experience, which are very, very crucial to become a competition lawyer. So I will tell you the proceedings before MRTP Commission, or for that matter, before Competition Commission of India, they are proceedings of civil nature. So, section, it says that all for the purpose of discharging its function, the same power are vested which are in civil court while trying a suit.
Right.
So, my first suggestion for competition aspirant that at least 3 years they must devote in civil courts, so
Right,
that they may have a first-hand knowledge, which is very, very essential for doing the practice before the Competition Commission or in the erstwhile MRT.
Right, sir.
In my case, I had a experience of working in civil courts, criminal courts. So I gained that experience while servicing in the courts. So
Right, sir.
I was occupied with all these procedural aspects, and therefore I started from first day my own independent practice because of my background and experience. So
Right,
the
sir.
first requisite which a lawyer must have, that he must have some kind of experience, say about 2 years, 3 years in working in civil courts.
Right, sir.
That is first of the things which a lawyer must understand it. Directly, if he will jump into the competition law, he may not be able to understand what is all about, because more than 70% of any law, what to talk of competition law, it is procedural except.
Right, sir.
Cases are win and lost on the basis of procedural law. Substantive
Right.
law will come into play subsequently. So,
Right, sir.
as a practitioner, you must be aware of all these hurdles which lawyer has to learn as a for petitioner or for respondent. So,
Right,
that
sir.
is the first which you must remember it, or any other who wants to join the profession.
Right, sir.
The second point which require, or second skill which required according to me, is that competition law is an economic law,
Right, sir.
and historically blended with this subject of economics in its root.
Right, sir.
I will tell you little background of this history.
Right,
When
sir.
our country has got independent in 1947, immediately after, in 1948, first industrial policy was into play. What had
Right, sir.
happened after 10 years of it, our government of that day thought that the concentration of economic power is going in the hand of industry. How
Right, sir.
to curb it? Because richer was going to rich and poorer were becoming poor.
Right,
So first they have established the Hazari Committee, then Monopoly Inquiry Commission in 1965, and on the basis of which the MRTP Commission was established in 1969.
right, sir.
So this history of economics is embedded in the competition law.
Right,
Earlier
sir.
it was MRTP Act, now you may call it a competition law. That was also a competition law. All kind of anti-competitive practices were there. It's according to it, it's a change of a forum as well as change of the name of the substantive provision. Nothing more, nothing less. So
Right, sir.
any advocate who wants to become expertise in the competition law, he
Right, sir.
must have a solid background of economics while doing his LLB.
Right, sir.
So he must stop one of the subjects of economics. It will
Right, sir.
facilitate his journey as a competition lawyer.
Right, sir.
So you got it?
Right,
That
sir.
first quality is that you must have a expertise over civil procedure.
Right, sir.
And the second skill is that you must have a basic knowledge of economics.
Economics. Right, sir.
Competition law is a mixture of economics and competition. It's
Right, sir.
not purely a law.
Right, sir.
So you must understand it that it is a combination of economics and law.
Right, sir.
You see that what is cartel, what is anti-competitive.
Right,
Behind
sir.
it, there is a economics,
Right, sir.
demand and supplies, cost and price,
Right, sir.
all these things related to economics.
Right, sir.
So this was the second point which I wanted to emphasize. And third point is that you must have a reading of old MRTP Act, which has
Right, sir.
been repealed from 1st September 2009.
Right, sir.
Why I am saying so, if one may go to the root of this legislation, that is the Monopoly Inquiry Commission 1965,
Right,
it's
sir.
a thorough judgment.
Right,
And at that time, it was really, they have worked very hard
right,
and
sir.
they have created this MRTP Act.
Right, sir.
So anyone who is interested in practicing, he must go through the old judgments of the Supreme Court under MRTP Act and
Right,
also
sir.
the Monopoly Inquiry Commission report, so
Right, sir.
that he may have a grip of the subject at the
Right,
threshold.
right, sir.
Because what I have seen that many of the lawyers, they do not aware of what was it. And
Right,
they
sir.
want to start their journey halfway, virtually
Right,
the later part. The
right, sir.
initial halfway, they did not read the MRTP Act.
Right,
Therefore, they have some kind of a confusion that what should we do?
right,
Because
sir.
they have not gone through the initial part of the, and from my experience, I can tell you this is very, very important. One
Right, sir.
must go through.
Right,
So
sir.
we have three skills which a lawyer must require. One, experience of civil court,
Right,
then knowledge of economics, and
right, sir.
third, study of MRTP. And
Right,
the
sir.
fourth one, which is also important, that the competition law is so vast
Right, sir.
and it requires a regular updating.
Right, sir.
If you are not in touch with branch for 15 days, you are not aware how many changes, how many judgments have come during this period, not in India, but globally, which
Right, sir.
will handicap you to understand the subject.
Right, sir.
So I am of the firm believer that a lawyer who wants to practice in this branch of law, because it has a very limited time, qualitative time to read the material.
Right, sir.
A lawyer, every lawyer has at least 2 hours, 3 hours for regular readings. Otherwise, he
Right,
is busy in routine kind of a work.
right,
So
sir.
to update its knowledge, to study during qualitative time, it is very, very essential that he must devote to this branch. And
Right.
my suggestion is that it is very difficult, if not impossible, to divert in other branch of law. So
Right.
competition law requires a full-time lawyer. It's
Right.
not half-hearted that you do this branch also, other branch also.
Right, sir.
According to me, you may not be justifying with the subject.
Right,
And
sir.
in turn, you may not be justifying with the client also.
Right, sir.
So it is very, very important. Even if now you see that many of the big law firms, they have a separate team of competition lawyers
Right, sir.
because you cannot cope up with the requirement of the client.
Right,
Because
sir.
you have rightly said, this law is a dynamic law, keep
Right, sir.
on changing.
Right, sir.
So this is the fourth requirement or skill which
Right, sir.
I can see in a lawyer who wants to be a competition lawyer.
Right, sir.
And above all, if
Right, sir.
not last, but above all, he must have a passion about the subject.
Correct, sir.
Unless he dream about this subject, he may
Right,
not
sir.
be able to get through it.
Right, sir.
Because you have to create your own imagination.
Right, sir.
When I was practicing under the MRTP Act, I normally say, you come with any problem, we will try to cover under MRTP Act.
Right.
That kind of a passion every lawyer must have. Unless
Right.
that kind of a passion is not there, it's very difficult that you may become an expert.
Right,
So
sir.
I
Yeah.
can recollect these 4, 5 kind skills which a lawyer must have.
Right, sir. So this is absolutely, this was very, very insightful, and it was first-hand wisdom that you have, placed before our audience. This is nothing but first-hand wisdom, and I would, encourage all my viewers, all readers who will be watching this to kindly take down these, very important suggestions, because this is coming from someone who has seen many lawyers come and exit out of this field. And sir, I absolutely agree that this field requires a regular reading and a regular update of knowledge, because it's apart from being dynamic, the thing is that the markets are changing every day. And you would know that better than me, sir. Markets are changing every day. And the moment the markets change, the way enterprises function in those markets also change. And therefore, new kinds of anti-competitive practices or challenges come into play, and we will also talk about that during the last part of this conversation. So I'm absolutely agreeing to that this requires a very devoted practice. And of course, as you said, civil court practice is necessary, but once you are through with that and once you're into the field of competition law, it requires a lot of hard work and a lot of devotion to the practice. And that is very important, sir. Now, sir, moving on to your upcoming work. First of all, sir, many congratulations on your upcoming book, that is Indian Competition Law,
Thank you.
Analysis
Thank
of
you.
Procedural Aspects and Decisional Practices. So, sir, I just want to ask you a question about the book itself. What inspired you to write this book, and what are the things that you are intending to cover, through this book?
Uh, to answer this question, Shashwat, firstly, I may say that I have spent almost 50 years,
Right, sir.
all my life in judicial system. Right
Right.
from 72 till date, it's almost 50 years that I am attached with the judicial system. 21
Right.
years I have spent in a subordinate position in courts and
Right.
gained the experience in various branches of law, whether it
Right.
was civil, criminal, custom, excise, or for
Right.
that matter, MRTP. So 21 year I was gaining the experience And at the same time, I was increasing my education degrees also through evening courses
Right.
and courses.
Right, sir.
So, as a lawyer now, 29 years I have spent in this.
Right,
So,
sir.
I will tell you that the period of COVID compelled me at the
Right.
advanced age of nearly 70 years to confine at home.
Right.
I had no
Right, sir.
work, we could not move. So this was
Right.
the time when I thought, let us share my experience with the society.
Right, sir.
And I started writing. I had never mind that I can publish a book, but I
Right.
started writing in the shape of articles, which
Right.
ultimately culminated into a book. Although these articles were planned in such a way that finally it may get into the book. So,
Right, sir.
this period of COVID, in the first phase, I have written a book on substantive provisions and decisional practice on competition law.
Right,
And
sir.
this is my second book on a procedural line. So,
Right, sir.
if we combine both these books, it would be a compendium on a competition.
Right, sir.
So, coming to the second book,
Right,
in
sir.
this book, I have raised many questions on procedural law.
Right, sir.
According to me, there are certain deficiencies in this procedure
Right,
which
sir.
is not being followed by the competition law authorities.
Right, sir.
And I have stopped these chapters or articles at a point where further researcher can start
Right, sir.
further research on this point.
Right.
So this book is virtually categorized into 8 chapters. First chapter, I will tell you, is dealing with combination or concentration of economic power, whether pre-notification from 1st June 2011
Right, sir.
requires reconsideration. It's very, very important. Here, I have
Right.
challenged that under the Competition Act, it is not at all necessary.
Right, sir.
According to me, that
Right, sir.
by the amendment of 27th September 1991,
Right, sir.
government has deleted the provisions regarding concentration of economic power from the MRTP Act. In the garb of liberalization, globalization, then what are the circumstances for Raghavan Committee to again introduce in
Right, sir.
1999? So I put a question mark whether this regime of pre-notification is at all necessary. Because regulation of combination
Correct,
is
sir.
nothing but enforcement of section 3 and 4 relating to anti-competitive agreements and abuse of dominance. So regulation doesn't
Right.
include the substantive. In regulation of combination, they will see
Right.
whether there is a violation of section 3 or whether there is a violation of section 4. When both
Right.
sections are there, according to me,
Right, sir.
it was not necessary. So it is a wider subject
Right, sir.
which any researcher can take this guide and he can do his further research in this matter, whether we require it or not, particularly in view of amendments
Right.
of 27 September 1991 under the MRTP Act. So this was first chapter.
Right, sir.
So second
Right, sir.
chapter was MRTP this competition commission is they are adjudicating the matter. Section 3 and 4, what they are doing is they are applying the civil
Right,
law,
sir.
and finally they are putting a cease and desist order and penalty. So this is a adjudicating process. Supreme Court had said so in the first case of 2010 of
Right.
sale also, that they are adjudicating that. Now the question in second chapter which I have
Right, sir.
raised, that whether the presence of judicial member required while adjudicating the member, because
Right, sir.
they have taken the jurisdiction of courts. Unless there is a
Right, sir.
judicial member, it is not complete. If we go by
Right,
the
sir.
ruling of the Supreme Court in utility builder, they have categorically said the presence of judicial member is necessary.
Right, sir.
And we have seen that for the last 4 years, there is no judicial member.
Right, sir.
So, according to me, that the presence of judicial member is a basic structure of constitution which requires
Right,
the
sir.
presence of the judicial member.
Right, sir.
And this matter is pending before the Supreme Court. One or the other day, they will have to decide. But I am of the
Right, sir.
firm believer that it must be. Even in MRTP Act, the chairman was
Right, sir.
a retired High Court judge.
Right, sir.
Here we are talking that, okay, not chairman, at least one member must be there.
Right, sir.
It is not there. So we were talking that first chapter relating to whether notification with effect from 1st June 2011 of
Right, sir.
combination matter, whether it was really essential, particularly in view of the amendment of 27 September to
Right.
1991 under the MRTP.
Right, sir.
My second chapter relates to whether the presence of judicial member, we
Right.
are not talking of chairman, we are talking of a member, is
Right, sir.
essential while adjudicating the matter before the CCA.
Right, sir.
And now we third chapter relate to role of Competition Commission of India vis-a-vis other statutory authority.
Right, sir.
This is covered under section 21 and 21A.
Right, sir.
And Shashwat, you would be amazing to note that both sides, even other authorities or competing, they are very reluctant to send any requisition to other authorities to
Right,
take
sir.
their opinion. And
Right.
it affects the judicial time.
Right, sir.
Rather, it should be obligatory on both the authorities
Right, sir.
to refer the matter before taking cognizance under section 26(1) to let us have a view of or not.
Right, sir.
And it really spend not only waste the judicial time of CCI, rather of high courts and Supreme Court also.
Right, sir.
Ultimately, this subject was ultimately decided by the Supreme Court in Bharti Airtel matter.
Right, sir.
There was a dispute whether TRI has a jurisdiction or CCI has a jurisdiction over telecom operators.
Right, sir.
Commission said no, they are indulging in cartel.
Right, sir.
TRI said no, they are not giving the point of connection to the, therefore they are violating the TRI Act and they have a jurisdiction.
Right, sir.
So this dispute first went to the Bombay High Court before single judge. then it
Right, sir.
went to the double judge, then
Right, sir.
ultimately it leads to the Supreme Court,
Right,
where
sir.
all the parties have preferred appeals. There were
Right, sir.
4 or 5 appeals. Bharti
Right,
Airtel, Vodafone, Association of Telephone Operators, Competition
right,
Commission of India. It's a sheer wastage. If they will agree that before passing 26(1) order, they may refer the matter.
right,
So
sir.
in this chapter, I analyzed this and said that even if statute provides, but authorities statistics
Right,
show
sir.
that they are not bothered about.
Right, sir.
So you have seen that the trend is that these chapters are of critic nature.
Right, sir.
I am saying I am not correct, but I am seeing these circumstances give suspicion that
Right, sir.
they are not correct.
Right, sir.
It is the time which will tell whether I am correct or not. And
Right, sir.
therefore, for each subject, the students, academicians, researchers, they can take this point further from where I have left. So
Right, sir.
according to me, there is a lot of scope for researcher. Once they will go through it, they may get a clue and take their research further.
Right, sir.
Now, the 4th chapter was also very, very interesting. In this section 26(1),
Right, sir.
the proceedings start before the commission only after passing 26(1) order. That is a prima
Right, sir.
facie. And Steel Authority of India said commission is not bound to follow the principle of natural justice while passing 26(1) order. Means
Right,
there is no requirement to give a notice to the respondent side.
right, sir.
So these orders are being passed by the CCI without hearing the respondent.
Right,
So
sir.
this give a arbitrary power to the CCI.
Right, sir.
So these orders from the day one, the competition substantive provision were enforced with effect from 20th May 2009. They are being challenged in various high courts.
Right, sir.
Sometimes this way, sometimes that way. And ultimately, as I told you, in Bharti Airtel case, it was only 26(1) order. So
Right,
there must be some kind of a mechanism by
right,
which a fair kind of a thing must be done by the CCI. I am not at all propagating that CCI is not doing fair. They are doing at their best. They are doing very good. But
right, sir.
circumstances give certain point that these orders sometimes looks like an arbitrary one.
Right, sir.
So this was then I have dealt with the transition from reformative to punitive theory also. You see that under MRTP Act, it was only cease and desist order was required to be passed.
Right, sir.
Because initially when it was started in 1969, this act
Right, sir.
was new to us.
Right,
The
sir.
government thought it that let the traders may be disciplined only. There should not be any pecuniary penalty. Therefore,
Right,
they
sir.
said if you have violated the uh, sections of MRTP Act, only they said don't do it in future. This
Right, sir.
terminology called cease and desist order.
Right, sir.
But under the Competition Act, under section 27A and B, they have a wide power of imposing the penalty to the
Right,
tune
sir.
of 10% of their turnover.
Right, sir.
So now competition practice has completely changed
Right, sir.
because of high stakes.
Right, sir.
Now individual lawyer,
Right,
it's
sir.
very difficult for him to do independently because of stakes.
Right, sir.
Every corporate wants some firm who may handle it efficiently,
Right,
which
sir.
require a infrastructure and other things. Therefore,
Right, sir.
I am not hesitant to say that the present practice of competition hack has become institutionalized. It
Right, sir.
has to be done by firms, law firms who have infrastructure and have a dedicated team.
Right, sir.
So practically the individual lawyers, they are doing it, but they are
Right,
not getting the client corporate client.
right,
That
sir.
is the difficulty.
Right,
So this penalty has forced the corporate to think their strategy, rethink their
right, sir.
strategy. And in this chapter, I have stated what type of penalties are there, what they can do. All this has been narrated in this.
Right, sir.
Then there is a consent order also.
Right, sir.
Next chapter relates to consent order, that is
Right,
commitments and settlement.
right, sir.
I will tell you one secret about this topic also. Under
Right, sir.
old regime of MRTP Act,
Right,
these
sir.
provisions were there.
Right, sir.
Section 37(2)
Right, sir.
relating to restrictive trade practice gives power
Right, sir.
to the commission. Anybody comes to him, sir, I will not do it in future. He simply give an undertaking, commission closed the inquiry. This
Right, sir.
was the commitment and settlement.
Right, sir.
But when Competition Act was introduced in 2002, these provisions were not there.
Right, sir.
But now again they wanted to reintroduce it, and the bill
Right,
is
sir.
pending before the Parliament.
Right, sir.
Competition Amendment Bill 2020 is pending.
Right, sir.
So again they are reverting to that. So
Right, sir.
like that, next question is whether commission can issue mandatory injunction.
Right, sir.
Commission being a quasi-judicial authority, they
Right,
cannot
sir.
issue mandatory injunction. It
Right,
is
sir.
only the civil court under Order 39, they have a power to issue mandatory injunction.
Right, sir.
But they are passing in one of the case, they have issued it. Then they went to the Gujarat High Court, they stay there. So I think so. All this happening because there is no judicial member. If there is
Right,
a judicial member, they would have taught them. Don't do it.
right, right, sir.
So all these things,
Right, sir.
then leniency in cartel cases,
Right, sir.
etc. So all these things are there in this book,
Right, sir.
and I suggest it is a critic book, and uh, I can't write it that everything is going on fine, but
Right, sir.
with the help of decided cases, I have tried to show that the lacunas and other things in the procedural aspect.
Right, sir. I think so.
So
This
I
book will be
recommend that.
absolutely monumental. I think this will be very, very helpful for law
I
students.
won't call it a monumental, but I am sure that it may help student to, because you see that what is the function of a lawyer?
Right.
Lawyer needs to be a critic.
Right.
He has to float a new idea. Unless he float
Right.
a new idea, he's not a lawyer.
Correct, sir.
So idea has to be a new and critic one.
Right, sir.
One lawyer has to think out of box. He should not
Right.
confine his thinking.
Right, sir.
Therefore, he can become a good lawyer, whether in competition law or any other law.
Right, sir. I think so. These are very, very
I hope
important
your
procedural aspects that you've talked about, especially the presence of a judicial member. Mandatory injunctions have been talked about a lot in the past 2 years because of the new cases coming up. So these are very, very important topics of of contemporary relevance as well, because procedural
correct,
challenges will
correct.
always be there. Substantially, what is an anti-competitive practice or what does not amount to a practice, that can obviously change with time, but these procedural issues, they will always exist, and a lawyer needs to be thorough with these. And I'm very, very uh, I'm agreeing to the fact
No,
that these are very important.
you see that Shashwat, in my first book, I have
Right,
also criticized the approach of the CCI while
right, sir.
dealing with the substantive provisions
Right,
with
sir.
reference to the decisional practice.
Right, sir.
In that book, I have dealt with section 3 and 4.
Right, sir.
So that book also of its own kind, and
Right, sir.
with the help of latest case law, uh, uh, I have tried to do the justice with this subject, and it
Right,
is
sir.
for the reader to decide whether I was able to do that or not.
Right.
That much I can say.
I'm fairly hopeful so that everyone will like this book, and it will be very, very important for the young practitioners. Now, sir, moving to the very last part of our conversation, and this is something that is, on the minds of every competition law enthusiast these days. And you have been reading these updates not just from India, but from jurisdictions such as United States, European Union, UK, as well as other jurisdictions around the world, wherein competition regulators are facing many new challenges because of the digitalization of markets, be it anti-competitive practices or the ways in which these companies, these dominant entities, are abusing their positions because of the data effects, the network effects, all of these things. They are presenting very new challenges to the regulators. So, sir, in your opinion, how should the regulators update themselves and approach these challenges? And there also a need to reform the laws along the way?
Okay. Uh, Shashwat, I will say that no doubt that digitalization of market is generating some very complex issue for competition regulator, not only in India, but around the world. There is no doubt about it. Therefore, response to this query in this kind of talk, which is a very limited time, is certainly difficult.
Right,
But
sir.
in spite of this difficulty, I will try to give my answer in brief within a time stipulated and
Right,
try to convince that what is the position at all.
right, sir.
First of them, one has to understand what is the digitization of market. This
Right, sir.
concept itself is a very wide. So,
Right,
according to me and the material available on digitalization of market means providing one or more so-called platform service. So,
right,
digitalization is providing a platform service like
right, sir.
app stores, marketplaces, search
Right, sir.
engines, social network, video sharing,
Right, sir.
communication app, operating system, cloud computing, web
Right, sir.
browser, etc., etc. So,
Right, sir.
digital marketing means core platform service. Now,
Right, sir.
which are those in our country or around the world? There are number of such core platform service providers, including Alphabet, Apple, Amazon, Meta, and micros.
Right.
So these platforms, when we talk about digitalization of market, means these platforms are indulging in some kind of a anti-competitive practices or abusing their dominance under Section 4. Is that clear?
Right, sir. Right, sir.
So Competition Commission is very active. They
Right.
are doing recently they have e-market commerce. They have studied
Right.
the e-market commerce also, that is available on their website. Otherwise, they are
Right.
doing very and cover. But
Right.
you see that Section 3 of the Act is dealing with the anti-competitive prohibitive agreements. There
Right,
are
sir.
of three nature. One is
Right.
journal agreement, Section 3.1.
Right,
Second
sir.
is horizontal agreement, Section 3.3. And
Right, sir.
third one is vertical agreements, Section 3.4.
Right, sir.
So virtually these platforms are normally indulging in vertical type of a prohibited trade practices. It is
Right,
not
sir.
that they are not indulging in horizontal, but
Right.
chances of horizontals are very less. It is
Right,
only
sir.
the vertical agreement.
Right, sir.
And CCI is fully equipped within the
Right,
present
sir.
regime to deal with any kind of it. And in fact, they have done a lot of cases during
Right, sir.
against these companies.
Right, sir.
Now, I will come to your second point, whether we require some new legislation or some amendment in these to deal with these kind of a situation. In this
Right, sir.
regard, I will tell you that Competition Law Review Committee,
Right, sir.
CLRC, it was a high-powered committee
Right, sir.
which was constituted on 1st October 2018 by the
Right, sir.
government to suggest what amendments
Right, sir.
can be done under the present Competition Act.
Right.
And according to that committee, they have submitted their report on 26 July 2019. And
Right, sir.
I request your readers also to
Right,
go
sir.
through that report. It is available on the internet also and on the site of the CCI also. They will
Right, sir.
have a first-hand knowledge of reading that report. It's very
Right,
good
sir.
report.
Right, sir.
In this report, Chapter 8 was dealing with the technology and new age market.
Right, sir.
They have devoted one chapter to how to deal with the new age market like digitalization.
Right, sir.
So according to them, they said commission is competent to
Right.
deal with anti-competitive agreement.
Right,
And
sir.
they said there is no need for any
Right.
kind of amendments.
Right, sir.
However, they have said that with regard to hub and scope agreements, hub
Right,
is
sir.
a center,
Right, sir.
spokes are the competitor.
Right,
According
sir.
to them, this is a gray
Right.
area where spokes competitor can be caught in cartelization or anti-competitive. But
Right, sir.
the platform, they may escape from that. For
Right,
that,
sir.
they have suggested certain amendment in the Competition Act and with
Right, sir.
minor changes also. And on
Right,
the
sir.
recommendation of it, Competition Amendment Bill 2020 was prepared and presented to the
Right,
Parliament, and it
right,
is
sir.
awaiting decision of the Parliament. And once it is
Right.
there, I think so, the second lacuna, which is there, will also be covered under the
Right, sir.
Hub and Spoke Act. I think
Right,
so.
sir.
Uh, you have got the answer in the
Right,
shortest
sir.
time. Otherwise, we can discuss this subject as a whole for hours together. There is
Right,
no
sir.
difficulty.
Of course. And sir, that is very, very informative. Once again, just one, I think, one point of contribution from my end is also with respect to combinations. On that front, the CCI is deliberating, and I think there are some amendments in place or would be in place wherein they're trying to change the criteria to assess these combinations. Right now, uh, it is on the basis of turnovers of the enterprises that are involved within that combination, and uh, now it would be according to the deal value also. And now CCI has already, in some of the decisions, some of the opinions, started taking these network effects into consideration for these virtual, or these internet platforms. And I think this would be another change that is being talked about. So,
Uh, okay.
yes, sir.
May I answer? May I
Yeah,
answer
yes,
your
sir.
question?
Yep, sir. Yes, sir. Absolutely.
Shashwat, you see that I am firm believer that out of 100 combination cases,
Right, sir.
more than 98% cases, Commission has cleared on as it is basis because
Right,
there may not be any competition.
right, sir.
So what survives of only less than 2%?
Right, sir.
So I am of the firm believer that combination provisions are not substantive provisions. In
Right, sir.
combination, what Commission is looking is whether there is any anti-competitive agreement. With
Right, sir.
regard to anti-competitive, in 2020, they have even deleted the non-compete clause.
Right, sir.
I don't know why they have deleted the non-compete clause.
Right, sir.
So, according to me, the combination provisions are secondary in nature. And
Right, sir.
particularly, how many percentage of the combinations are being actually attracting the section 3 or 4.
Right, sir.
So I am firm believer that the pre-notification should not be there.
Right, sir.
It should be after Commission may choose any case and they may start investigation. Who is
Right,
stopping them?
right,
But
sir.
for pre-notification, even startups, when a big company is taking their share, even they have to give their, once the
Right, sir.
threshold limit is crossed.
Right, sir.
So I once again reiterate what I have said earlier that in view of notification of 27 September 1991, this pre-notification for the timing in our
Right,
country is not necessary, and
right,
central government, at least for 5 years, they
right, sir.
say so that we will look after 5. So
Right, sir.
what they are going to change, they will sometimes say, no, we will issue green channel. What is the purpose of green channel? Party may give the information, they will say, you go through it. You
Right,
have
sir.
seen the Reliance and Future cases. They have ordered it 31 1 के अंदर. Now they are saying that we are withdrawing it. How is it possible?
Right,
Commission has not been given any power of review.
right, sir.
So, so with regard to combination, I am not comfortable. Whatever they
Right,
are doing, that they may continue to do it. But
right, sir.
according to me, it should not have been.
Right, sir. That's again, sir, a very interesting outlook. And so with that, we come to an end of this wonderful conversation. And I would once again like to thank you, sir, for joining us today. It was an absolute honor for us to host you. And thank you so much, sir.
I will just give my concluding remark that
Right, sir.
competition law is a dynamic law and keep changing with the passage of time and situation, not
Right,
only in India but globally. Therefore, it requires regular updating in case one may continue to be relevant in this branch of law.
right, sir.
So, all the best to the young aspirants
Right,
and
sir.
my good wishes to you and all your readers. Thank you very
Thank
much.
you so much, sir. Thank